Ghanatube so number one channel and news so any day eba ewo man nyeko na hwe na papa na so ne so na ya bremu na mahu na Martin sem so any day eba ewo oman ni mu na emom ni sem ni wo ho na se beto dwa na emu eyedu e de man se ye be kan se no de ehwe ahwefo se mo be ko akotia akohwe nsem so any day eba ewo man na se ye ba ebi kan ho ye be so e de ama ya hwe.
Here on Ghana Tonight, the Attorney General is urging an Accra High Court to dismiss a case filed by the suspended Chief Justice, Ꞇourt Tokono, her ladyship, Justice Ꞇourt Tokono. Now, we've got details of exactly what the Attorney General is asking of the High Court. But earlier today, we got information of the Attorney General urging an Accra High Court to dismiss a case filed by the suspended Chief Justice Ꞇourt Tokono. Documents filed in court by the Deputy Attorney General, Dr. Justice Shemsai, is arguing that the matters raised by the Chief Justice have been dealt with or remain pending at the Supreme Court. Now, the Chief Justice has, in the last few weeks, if you recall, urged the Supreme Court and now the High Court to halt her removal process. In fact, this action by the Chief Justice is the sixth legal action that has been filed in court since the presidency announced the receipt of the petitions against the Chief Justice. We're going to get into the details of it. Let's recall exactly what the Chief Justice, when she addressed the press last week, indicated about a judicial review. And my colleague Joseph Akable, is a legal affairs correspondent, is with me in the studio. We'll get into the details of the Attorney General, in fact, the state's contention against the CJ's position on this matter. Joseph, it's good to have you.
Always good to be here.
Perfect. Let's set the tone, shall we? Recall what Ꞇourt Tokono, her ladyship, said last week regarding this judicial review. Let's get into it.
It is this total absence of compliance with all known rules of fair hearing that has caused my lawyers to file application for judicial review in the High Court to declare all the proceedings void. Because the clear danger is that through this flagrant violation of CI 47.
So that's the position as espoused last week. Let's get a bit more detail about the latest action and the decision as communicated today by the Deputy Attorney General who filed in court today.
And so in substance, what the state's case is a simple one. The Attorney General makes the point that the matters that are being raised by the Chief Justice are matters that have been dealt with in one way or the other by the Supreme Court, and there's also the possibility that if they've not been dealt with, it remains pending at the Supreme Court to the extent that the court has dealt with injunction aspects of it, and so the substantive matters remain outstanding. And so if that is the case, then why take the same matter to the High Court? And so we're going to start off first with the very latest that has come through. The latest is that the AG is asking the High Court to strike out the case that has been filed by the Chief Justice. Let's walk you through where we've come so far. So the pending cases that he makes reference to, that a number of cases are pending. First is Her Ladyship Justice Ꞇourt Tokono versus the Attorney General and 5 others. That is the case that went to the Supreme Court where the lawyers for the former the suspended Chief Justice, led by Godfrey Ꞇourt Dame, had argued and urged the Supreme Court to halt the proceedings. You recall he had made reference to things that had occurred at the hearing of the committee, and the Supreme Court took the view that those matters are not matters that should be contained in the affidavit due to Article 1468, the requirement of it being an in-camera proceeding, and so the court struck out that particular matter from there. The other case that is also at the
for any TF1 some so any the airport woman and not just say we need to our share we tea na we share na adwenture our for nsem na we ja fefe e de mame e wo comment section ho yanko enyanko see here to us.
Supreme Court is the one filed by the Center for Citizenship, Constitutional Electoral Systems versus the Attorney General and 2 others, also raising procedural issues against the entire process. You recall the very famous one, Vincent Eko Asefua versus the Attorney General. That is by the Member of Parliament. He took the matter to the Supreme Court. Also represented by Godfrey Ꞇourt Dame, the former Attorney General. That matter also went to the Supreme Court. An injunction application was dealt with. The substantive matter remains at the Supreme Court. Ebenezer Osei-Owusu was also one that the private citizen who had also asked for an injunction as well. That matter was also disposed of by the Supreme Court by way of the injunction application, but the substantive matter remained at the Supreme Court. Then there's another one of Ḥoidor Kofi Atta-Korte versus the Attorney General as well. The latest action is the one filed by Her Ladyship Justice Gertrude Arabai Sabato versus the Article 146 Committee and 6 others. She actually names the members of the committee as part of this judicial review action, and the sound that we played was her talking about the fact that she had instructed the lawyers to file this process, and she had explained that, well, she's not going down without a fight. She makes the point that as far as she's concerned, she believes that she has to take the steps to defend it, else they risk the possibility of people saying that what has transpired is right and can happen any other time. So let's take a step further and look at what she's raising in terms of the content of the judicial review application. She makes the point that up to now, there has been non-disclosure of the prima facie determination. You recall that once the petition went over to the presidency, the president and the Council of State came to a decision that, well, there's a prima facie case against her. The Chief Justice in a press conference made the point that, well, it's only fair that she's given a determination of the prima facie case so that she knows that among the list of allegations contained in each of the petitions against her, which ones have crossed that threshold and which ones have not crossed that threshold. She raised that same matter in the application for injunction at the Supreme Court. The court did not heed to that particular request that she made in respect of that particular point. Nonetheless, she's making the same point by way of the judicial review at the High Court. She goes on to say that her rights have been violated. If you recall in that press conference, she talked about how when she arrives at the Edu Lodge, she is thoroughly searched. She made reference to the fact that her family members are not allowed in there as well. Her phones, laptops are all taken from them as they go into the place. And she makes the point that even the venue itself, a secure facility, which she drew the connection with the plots and issues surrounding the murder of the judges and all of that point that she made over there. She goes on to say that the membership of the committee, you recall in that press conference, she specifically mentioned Justice Gabriel Scott Pamai, who is the chairperson for the 5-member committee. And the point she made was that one of the petitioners, that is Daniel Ofori, the petition that he filed, he had made reference to the fact that the Lord Justice who is presiding over the proceedings will be a witness that will be called upon to testify, because he was on the panel that resulted in his arrest. You recall the court was sitting, a determination was made against the lawyer. The lawyer was not unhappy about it. The lawyer proceeded to make various comments in the courtroom. The court was displeased with it. They ordered his arrest, and that formed part of the petition. So that has to do with the Akologo one. The legal practitioner's petition. And she makes the point that, well, Justice Pama was part of that panel. Then in respect of the Daniel Ofori one again, she makes the point again that he also participated on that panel as well. And so she adds all to that to say that that membership of the committee is also problematic. But all these are matters that the Attorney General is replying to. And the Attorney General is saying that first, the matters raised have already been dealt with or pending at the Supreme Court. And so as a result of that, the case should simply be struck out. And the next date for the hearing is on the 15th of July 2025. And we expect the legal arguments to take place in respect of whether the judicial review application that has been filed by the suspended Chief Justice should be allowed to remain at the High Court, or it should be struck out by virtue of the points that are being raised by the Office of the Attorney General.
Essentially, is the contention of the Attorney General by extension the state that the matters pending before the Supreme Court have a bearing on the application for judicial review by the suspended Chief Justice?
Yes.
But that's for the High Court to determine, is it not?
In fact, already the legal experts are pointing out to the fact that, well, what you've taken to the Supreme Court how to do with its interpretative and enforcement jurisdiction. And they make the point that the court was being asked to apply various provisions of the Constitution. And they say that, well, look, if you take a look at the High Court's jurisdiction, the judicial review, what is provided for under Article 141, they make the point that it is a power that is exercising power over administrative bodies, quasi-administrative bodies, and all of that. And so the grounds for such an application, they make the point that is quite distinct from seeking the interpretation and enforcement of the Supreme Court.
For any for some so any the airport woman and not just say we need to our share, we see now we share in adventure, our for and some that would just fair Eddie Mammy, our comment section ho, young queen, you could see near to us.
But the AG disagrees with that contention, and he argues, in fact, the affidavit that is filed in support of the application, they make the point quite strongly that those factual matters that have been raised in a different form, and the Supreme Court has already pronounced on it or will pronounce on it by virtue of the fact that the substantive aspects of the case remain pending.
Let's stay with me. Let's have a quick conversation on this matter because of the jurisdictional matter that you just raised, and this is where I bring in private legal practitioner, lawyer Lawrence Rekon. He's joining us on Zoom right now. Counsel, good evening. Thank you for joining us. If you can unmute for me.
Good evening to your various viewers.
Perfect. Now, on the matter of the jurisdictional issue that Joseph just referenced, to the extent that the specific detail of what the powers of the High Court is regarding Article 141, and then also this quasi-judicial committee that is hearing the petitions against the Chief Justice. Now, the Chief Justice has gone to the High Court insisting on a number of things be addressed. Is it an application that would be described as, from where you sit, a certiorari in the real sense of the word?
Thank you, Mr. Okansi. Yes, I listened to Mr. Kable, and I agree with everything he said in respect of the opinions that has been shared by a section of lawyers. Now, what is the point? The point here is that there are 5 pending suits before the Supreme Court in relation to Article 146. That basically talks about the removal of superior justices of our court, including the Chief Justice, who is also a superior court judge. Now, they are there for the interpretation and other consequential orders in relation to the same Article 146. That, by so doing, they ask for an injunction. And as part of the injunction, some of the averments they made are in relation to the current application before the High Court, which is in respect of the application for judicial review, which has been filed by her ladyship. Now, the argument made by the Deputy AG, it's quite difficult for me to understand as well, because if you look at the suit before the Supreme Court, right, that was for interpretation of Article 146 and other related matters in relation to Article 146. Now, if you look at Article 141 of the 1992 Constitution, it states that the High Court has supervisory jurisdiction over all lower courts and lower administrative bodies. Now, the committee that has been set up by His Excellency the President is performing a quasi-judicial function. And as such, it is described as performing an administrative function. Therefore, the High Court under Article 141 has power to exercise that kind of supervisory jurisdiction over them. And if you look at the Constitution, it talks about when the High Court is exercising its supervisory jurisdiction, it will give orders in the nature of judicial review, such as certiorari, mandamus, quo and the likes. So, the Chief Justice is in the proper forum for enforcing or invoking the supervisory jurisdiction of the High Court over the committee. So that one, there is nothing wrong with it, because it is stated under Article 141. Now the question here is that whether the things that she has stated in her affidavit in support of the application for judicial review, okay, will be one that the High Court will find meritorious. That is a discussion that we can have, but we can't go into the merit of it. But for the forum, it is the proper forum.
I acknowledge the limitation that we have, and obviously we would not want to venture into matters of sub judice. But then again, one of the issues she raises is that she doesn't have
for any for and some I so any the airport woman and not just say we need to our share, we see now we share and enjoy our for and some that would jump fair Eddie Mammy our comment section ho young queen you could see near to us.
The prima facie established against her, she doesn't have a copy of it. And then also I recall last week during that press conference, she had indicated that she does not have a copy of the petitions that the committee is using for the hearing. But can it be the case, or is there any merit in that particular position that she suspects the details of the petitions being used or being relied on by the committee is different from the details of the petition that she has, which was made available to her by the president?
Mr. Kansi, the issues the leadership discussed in the media in relation to fair hearing, to the extent that she has not been given a written, reason, okay, for the prima facie determination, and also the petitions. To me, it's a bit worrying, because we know that she wrote a letter to His Excellency requesting for the petitions. And she was finished with those petitions, the 3 of them. So I'm surprised that at this stage of the committee's work, she will still complain about not receiving the petitions. What I heard her say was that when she went before the committee, she was expecting that the committee will give her the petitions. But once the president has finished you with the petitions, what other petitions are you expecting from the committee? Because the committee was set up based on these 3 petitions, and already the president has finished you with the petitions. So it's a bit difficult to understand what she wants. Don't forget, last week she discussed the petitions in the media. So the question here is that which petitions was she discussing? If she didn't have the petitions, what petitions was she discussing? It's difficult to understand. We all know she has the petition. So on that score, I tend to disagree with her. On the issue of prima facie, it's not one that, yes, it would have been desirable, let me put it that way, if His Excellency would have finished her with the prima facie determination. However, the question here is that without the president finishing her with the prima facie, okay, a reasoned written prima facie, would that negate the work of the committee, or is it one that the High Court can make a case that she has been denied fair hearing? That is a question the High Court will answer on the 15th of July 2025. And I believe when it comes to certiorari, it is right that you may satisfy the conditions for certiorari. However, because it is a discretionary power, okay, the Supreme Court has said in a number of cases, including the case of Republic versus High Court, General Jurisdiction, S Party, Kennedy Ohene Japan, that when it comes to certiorari, the court exercises a discretionary power, and you can satisfy the conditions. If they want to refuse it, they will still go ahead and refuse it. So we will all wait on the 15th and see how all this will play out. But let me quickly mention that when it comes to the application that has been filed by the AG, the application is to set aside the application for judicial review. So by practice, because the application was filed today, the court will hear that application first before they move to the substantive one that was filed by her ladyship for the judicial review. So if it happens that the court grants it, then it means there will not be any application for judicial review. But if they refuses, then whether on the same day or they will set another date to hear the application for judicial review.
I appreciate your thoughts on this and clearly giving us an indication of how the coming days will look like. Thank you so much, Lawrence Buampong. Reiko is private legal practitioner. Thank you for joining us here on Ghana Tonight.
My pleasure, Mr. Kansi.
Always. Now, Joseph, this is how the July 15th is a date to watch, is it not? And how the coming days will look like. Quickly.
Absolutely, because like you did indicate, there's going to be the first legal arguments that will take place has to do with the new application that has been filed by the Office of the Attorney General. That is what the court would have to hear and determine first. What we do not know is the implication of this on the pending processes at the committee, the hearing that is taking place at Ēdu-Lodge. We've not seen the process that has been filed by her ladyship, the Chief Justice, so we can't even tell whether a request is being made for injunction and how the committee will approach it. We know that in times past, the committee took the view that an application for an injunction will not restrain it. But all those are matters that will bring our viewers the very latest as and when we have more to share.
And rightly so. Joseph Akable, together with the legal team, is going to be following this.
ɛna mbrɛ me kwan na me di me si fɛfɛ ɛwɔ nsɛm a ɛkɔso ani de ɛba ɛwɔ man no Michelle ɛna yɛfrɛ me ha ɛyɛ Ghanatube sɛndɛ ɛna di kai a wohwɛ me video mɛhwɛ pa sɛ subscribe na wa share ɛde aman sisi ade ankɔ